speakers that looked at one specific case, but also keeping in mind that there are some wider considerations to what is going on, for instance, in Libya. Of course, we organized and planned this event way before the last draft was released a little over a month ago. So what our interest is mainly is in the constitutional design, or the design of design issue. That is, how did we get there? What was the function and the outlook that the CDA had when drafting / making a constitution? We know that in its own title, CDA had siaga, that is, had the drafting more than the making. But I think that Suliman will illuminate us on this. So without further ado, let me just briefly introduce the speakers. The first one who will take the floor is Suliman Ibrahim. He is graduated, I think, from the law school in Benghazi University, and has, ever since graduating, has also chaired the law school and also the center that on law and society. He's currently at Leiden University in the law school there, where he's working on a number of interesting projects. You have a private law background, so he's done a lot of interesting work on real estate property rights in Libya pre and post 2011. But of course, he has also been heavily involved in the transitional process, and especially looking at how the issues of the constitution have developed in Libya. However, in Libya needs to be understood in very wide terms, because the CDA has been working all around the places, right? Not just in Libya, the country. And the second speaker is Andrew Arato, and who is very widely known political theorist at the New School in New York, and his career speaks to a number of interests, some that are also very dear to the AKU, like, for instance, the question of civil society, and there's seminal work there on civil society and political theory. But the reason why he's with us today is because he has heavily worked on the transitions after the 1989. So for those of us who look into constitutional transitions, we know that the post-1989 transitions were the moment in which scholarship began to emerge. And of course, Andrew was a big part of that. So now that we're seeing a number of decades down the line a similar sort of dynamic, it's the first time that we see a regional set of transitions. It's our distinguished pleasure to have him here to somehow take a look at the Libyan case with a view of someone who has worked on the previous cycle of regional transitions. So I've taken too much time. Suliman will go first. He will give us more details on the case study, and then Andrew will illuminate us on the rest.
First of all, thank you very much for the Khan University for the invitation, and I'm looking forward to hearing your comments, because as you mentioned, I'm a specialist in private law, so constitutional law is not my area. However, I've been involved somehow in working with through Benghazi University, and working with the CDA, the Constitution Drafting Assembly in Libya, and that's how I get to be, in a way, interested in the constitution making, but I would like to have this comparative experience as well. So, the first thing, if we start, I think Libya now especially now, is in the news, but for different reasons. So the question is, can constitution be made in today's Libya? I think that's the first question that maybe will be asked. And in Libya, in today's Libya, you can see that we have two, or maybe even some people will argue three parliaments, three governments, three national armies, two national investment authorities, two central banks. So this dichotomy of institutions is there. However, we have one constitution drafting assembly. However, this one constitution drafting assembly, the CDA, now is deeply divided and has already passed several deadlines. The last one was in March 2016. We lost hope for some time after 1 year of simply deadlock. However, in April 2017, a new draft, and that draft this was the claim to be based on consensus. And it was interesting to see how much interest that draft generated amongst Libyans in different places. So it was a reason for hope, but one needs to be cautious, as we will explain. So I don't have that much time, so in 20 minutes, so I'll try first to just to show, it's not apart from the security issue, to show the reasons for, in a way, maybe pessimism, the concerns that are present in today's Libya, and how these concerns have so far affected the constitution making. So, if we think about, okay, I can just, maybe some people will come with additional concerns, but I can think of three main ones: regional, ethnic, ideological. So if we think of the regional concerns, this is the map of Libya of 1951. When Libya got its independence, it was a federal state composed of three regions: Cyrenaica in the east, so Egypt is in the east there, and then Tripolitania in the west, Tunisia and Algeria, those are the borders, and then Fezzan in the south. The claim is, why is it a concern? Mainly in the east, there is a claim that, okay, the east is the region, the rich region in terms of oil, natural resources in general. However, this is the claim, this region was heavily neglected during the Gaddafi's time. And now it is time to get justice to this region. So, at least this is the claim, the Cyrenaica, which is claimed to be the richest region in terms of natural resources, is, in a way, compared with Tripolitania, is less populated. To take the example of Tripoli, the capital in the west, almost 2 million people, almost like 2/3 of the Libyan population live just in one city in the west. So that's a concern. And we can see that there are some issues in terms of local governance and also the political system. These are, where this concern is manifested. In terms, for example, political system, is it presidential, and then the president will come from the west, or parliamentary, and in this case, more balanced system according to those from the east. Also, we have another concern. We have Arabs, the vast majority, but also we have minorities. We have Berbers, we have or Amazigh, as they like to be called. We have Tawar, and we have Tabo as well. And the issues involve the issue with language. So they would like to see their language treated in the constitution in the same way Arabic is treated as official languages. Also, state identity. Some of them, they say, okay, Libya, maybe even they object to the title Libya is an Arab state. So they say Arab is not needed there because Libya is composed of more than Arabs. In terms of national institutions composition, they ask for a quota in parliament, for example, in the two chambers, as an example. We have also other concerns, ideological concerns. We have Islamists versus civil current. Civil current, this is the term because, the secular is not like a preferred term in the Arab region. So in this case, they prefer to use another term, and this is accusation. So some of the Islamists, they say, okay, they are secularists. But the civil current, they say, okay, we are not secularists, we are simply members of the civil current. You can see, these are just examples. You have the Mahmoud Jibril, he's from the civil current. He was the head of the national allies who won most of the seats of the General Congress, and then you had Mohammed Suwan, he's the head of the Justice and Construction Party, the Brotherhood Party, and then you have Abdul Hakim Bilhaj, who was once a member of the Islamist fighting group, and then he formed his own party after 2011. There are different issues, but the main one is the issue about the role of Sharia. I must mention that the role of Sharia per se is not disputed in Libya. There are several surveys conducted by Benghazi University showing that the vast majority of Libyans simply think Sharia should be recognized in the constitution. However, the disagreement comes when we ask about, okay, what orientation, the Maliki school or other schools, also legal decision makers, should religious institutions, Dar Iftar for example, be given a say or not? Also codification, when you have Sharia in the constitution, what will be the effect on laws, mainly derived from European models? So these are the detailed questions on which there is a disagreement between those parties. So, to start with, after 2011, there was a question, should we have a constitution? That was the question, should we opt for a new constitution? What were the alternatives? One may say, okay, simply, you could just do with an amended version of Gaddafi's constitution. But this was no option for two reasons. The first one, there was no constitution say, because the ideology was simply against having a constitution. Gaddafi's ideology was, even though at the end there was some debate about it, but the end result was, okay, there were some laws of special nature, basic laws, but not a constitution per se. In addition, opting for Gaddafi's constitution was no option because many people would think, okay, it is against the ideology of the February uprising or revolution. Bringing the constitution of the monarchy back, that was an option. You can see here that old man just in front of Benghazi Court Square. It's the equivalent of Tahrir Square in Egypt. So simply, many people, at least in the East, started waving the flag without being asked to. Started also the national anthem. It was described, both were described as the flag and the anthem of the independence, not the monarchy. So the question then, since you brought back the flag and the anthem, why wouldn't you simply bring the whole constitution? We will come to this point later, but the end result was, okay, we should have a new constitution. And the argument was, okay, this is the first time the Libyans will have a real chance to debate their future. What does it mean to be a Libyan? So many at the time were, and that was the euphoria of the revolution at the time. We should have something new. So the Transitional Council issued a constitutional declaration in 2011. It's quite detailed for an interim declaration, but the main article is Article 30, which is called the roadmap. So the roadmap during the transitional period, would start with enacting a General National Congress, GNC. The GNC would appoint, a constitution drafting assembly. And you notice here, the assembly now, the drafting assembly is part of the GNC. So it is the GNC that would draft the constitution in reality. And then the CDA, or the drafting assembly, would draft the constitution and give it back, submit that draft to the General Congress, so it would be reviewed. If the GNC would approve that draft, then it would be put to a referendum. Public referendum, yes or no. If it is accepted, then it will become Libya's permanent constitution, and that's the end of the transitional period. So, however, this roadmap had to be changed for regional calls. The first thing, the GNC, the General National Congress, would be elected by the whole population in Libya. And obviously, the majority would be from the West. So the federalists in the East simply said, okay, we cannot do that. In the permanent constitution, we will ask for federalism as an option. But from the start now, we see it will not be an option, because simply in the West, federalism is not an option. So they said, since the GNC, the Congress, would appoint that committee, from the start, it's pointless to have the Constitution Drafting Assembly at all. So the NTC, the first transitional body, had to amend the Constitutional Declaration, two things. The first one, the Constitution Drafting Assembly would be composed of 60 members, 20 from each region. So you notice here, with regardless of the population, 20 from each region. And now it's simply imitating the experience of 1951, because the 1951 Constitution was drafted in the same way. The second thing, still the GNC would appoint a committee, but this time from outside the GNC, so non-members. This wasn't enough. So the Federalists said, okay, still not enough, because the GNC would simply select people whom the GNC would know that they would simply refuse federalism. So the end result was another amendment saying the Constitution Drafting Assembly would be elected by the Libyan people. So this was a big change. Also, the review power of the GNC was omitted. So simply the drafting assembly would draft the constitution, and once it is drafted, it would be submitted to the GNC. The GNC would put it to a referendum, but the GNC would have no say in it. So now a clear separation between the Constitution Drafting Assembly and the General National Congress. The interesting thing, referendum is still there. Because the idea was, okay, you would have an appointed committee, but then to guarantee that it is democratic and everything, then there would be a referendum. Now it is elected, still the referendum is there. I mean, Libyans cannot hope for a more democratic measure. However, it has made it quite difficult, to get that constitution. Now we see it. And then the GNC elections took place in February 2014, but the concerns I mentioned, the ethnic and ideological concerns, came again. The first concern before there was a question about how legitimate the CDA is, because simply the turnout for the elections was very low. People were disappointed with the General Congress experience, so they didn't vote for the CDA. So it is less than 10% of the entire population. I remember at the time we had a meeting with the UN mission in Libya, organized it, and there was a question, okay, how could the CDA compensate for this lack of legitimacy? Because the assumption is the CDA would bring a constitution that's the constitution of the entire nation. And then, is it a representative and inclusive body? The Amazigh or the Berber minority boycotted the elections. So in this case, out of the 60 seats, 2 became unoccupied. And also, in the city of Derna, some members of extremist groups, because their ideology, okay, democracy is un-Islamic, and so they prevented the elections, resulting in other 2 seats occupied. So 60 committee, it became 56 committee. And then the performance of the CDA. The CDA, the drafting assembly, produced several drafts. The first one was in December 2014. Actually, it wasn't a draft. It was simply thematic committees. The CDA was divided into thematic committees, one for local governance, another one for the political system, a third for human rights and freedoms. And in December 2014, they came with draft chapters. At the University of Benghazi, we organized a workshop and discussed them, and it turned out that actually some of them simply contradicting one another, because simply there was no coordination between these committees whatsoever. And then, a long time later, the CDA formed what was called the Working Committee. And this committee produced one draft. It was supposed to be based on the thematic committee's drafts, but in reality, they simply disregarded these drafts completely. And then, after receiving some feedback, they produced the second draft in February 2016. In April 2016, the whole CDA, for the first time, there was a celebration and they announced the final draft.
Sorry about that, I forgot to
I think it's my alarm.
Like Suliman, you're running late.
So it was announced as the final draft, and it was even sent to the legislative body, to the House of Representatives. So the House of Representatives will issue the referendum law. However, there was a problem, we will mention it later, and then the CDA has once again to resume work and produce, this time a year later, April 2017, last April, a draft that was produced by the Consensus Committee. So, and then just 2 weeks, less than 2 weeks ago, that draft was amended, and now it will be a subject for debate after in July, the 2nd of July. So, I think we don't have time to go through these drafts, but I think the common thing they have, the thing they have in common, or the thing they show clearly, is the lack of consensus there. So, if we take just the example of April 2016 draft, the final draft, simply out of the 56, there were boycotters from the West, about 11 members. Simply they saw the draft as one based on regional allocation, because a predecessor to that draft said that Libya would have 3 capitals: Tripoli, Benghazi, Sabha. Also, they changed the senates, where was divided equally between the regions. So even it was amended later, but to them, to those 11 members, it was too much, ignoring Tripoli, marginalizing Tripoli, so they boycotted the CDA. From the East, there were members who simply weren't satisfied, even with this regional allocation. Some of them were asking for a federal system, so no less. And some of them, because later the capital simply was, once again, returned to be Tripoli only, they said no, Benghazi should be the only capital, or at least Tripoli and Benghazi, as was the case in 1951. And the minorities weren't so happy, because all these drafts simply treated the languages, as an example, as national languages, not the state language as Arabic. So they boycotted the CDA. So it was, no go to vote, because according to the regulations, in order to pass any draft, you need 2/3. And simply now, you have 11 boycotting the CDA, and then 6 from the East, and then you have 4 from the minorities there. It was impossible. So what the CDA did, on the 16th of April 2016, they amended the internal regulations, saying, they didn't say that we amended it. They said, okay, this is the interpretation. This is a new interpretation. Because it is not clear in the regulations themselves. If you read them, they say 2/3 of members. But the question, members 60 members, or actual members 56, or present members at the concerned session? So they said it is the present members. And as a result, they were able, on the 19th of April, to adopt a draft. 34 out of 39. So it was final. There was a celebration, actually twice. I think they did it twice. They celebrated this occasion, and yeah, this is the real one. They sent it to the House of Representatives for issuing the referendum law. However, those from the East who objected to the draft, they challenged the decision to amend the regulations. They challenged it before the administrative circuit in the Court of Appeal in Beirut. And interestingly enough, and that I think related to the design issue, the defense of the CDA, or the remaining members of the CDA, was simply, okay, this is not an administrative decision. The CDA is not an administrative body. It is a constituent assembly. it is different. So it is not subject to the jurisdiction of the Court of Appeal. However, the Court of Appeal rejected this and simply quashed the amendment. So the CDA spent a few months debating what should we do, and then some people accused them of not respecting the Libyan judiciary. So at the end, they had to resume work, and then they formed a committee called the Consensus Committee, and this committee came in April 2017 with a draft. How different this draft is, I think it's quite good. I will mention some differences here. It's a big table there. So one of the changes, the Senate, the first chamber, in the old draft, April 2016, 72 seats equally divided between regions, 3 regions. While in the new draft, 78-30 to the west, 26 to the east, and 20 to the south. Distribution of natural resources, there was a percentage in the old draft, now the percentage has been omitted. Minorities, still no change, also no change at all. The role of Sharia, it's quite interesting because in 2016 there was a detailed provision saying that Sharia is the source of legislation, but then coming with a detailed definition of what Sharia means in accordance with the recognized sects and interpretations without being bound by any particular jurisdiction, opinions and methods of interpretations. And then the other important thing, the Constitution shall be interpreted in accordance with this. So in this case, subjecting the other provisions of the Constitution to Article 8, which constitutionalizes Sharia. In 2017, Islam is the religion of the state, the same. Sharia shall be the source of legislation, the same. But then the detailed explanation is no longer there. What does that mean? Some people see it as, like maybe in a way, making Sharia less dominant in a sense. Some people say it is the other way, because Sharia is still the source of legislation. And then also in the old draft there was a council called the Sharia Religious Research Council, still the same, but its role is just advisory. So, I mean, if you look at these changes, if you look at those from the West, most of them were satisfied with these changes. So in the consensus-based committee, they accepted the draft. They saw it as sufficient for them, less based on regional allocation. For the minorities, no change. So simply they kept their position, refusing the draft. For those from the East, they saw it as worse. I mean, before, it was clear that the East would be equal to the West in terms of representation, but now the equality is not there. 32 opposing 26. So from the East, they refused it. And instead of that draft, they submitted different ones. So it ended by having almost, I think, more than 5 drafts. One of them calling for a federal system, another one even calling for a monarchy system. So on the 22nd of May, the CDA adopted an amended version of the April 2017 draft. I haven't seen that version yet. It hasn't been leaked yet, because the other one was leaked, simply wasn't published. But for the time being, we know that Eastern members, at least 9 of them, they boycotted the CDA. They said in Cyrenaica, the notables and leaders in Cyrenaica refused this draft, and we need to simply to deliberate with them before coming back to the CDA. So they published a letter and they sent it to the CDA, and for this reason, now the CDA decided to suspend its work until the 2nd of July to see what those from the East will say at the time. So final remarks. I said it's optimism, but it is cautious optimism. It is optimism because if you think, because since 2016, I mean April 2016, sending the draft and we didn't hear anything at all. And people simply, even at the time, no one showed any interest in the draft, maybe because of the circumstances at the time. But in April 2017, when that draft was leaked, personally, I was amazed by how much interest people showed in it. So I think that's, at least, many people still believe in the Constitution as an alternative way to what's happening there. And from my personal view, the latest draft is largely balanced. But that's my own view. However, it is cautious because we still have the consensus problem. Once I was in a committee and we went to the CDA last year, just simply to see what's behind, I mean, like these disagreements between them. And in some cases we found some people their positions are quite rigid and they refuse to compromise and they think this is likely to continue. So building consensus is still a huge problem. And also we have a legal issue there. The CDA passed its deadlines actually, many times, 4 or 5 of them. The latest was March 2016. And actually now some people are waiting. They say it's pointless. Even if you have that draft, even if it is accepted in the referendum, we will go to the Supreme Court, which we are not having. And in Libya now people use the judiciary in this way very often these days. So alternatives, we have this call for the return to the constitutional legitimacy. They claim they are gaining support. Simply they say we should go back to the monarchy constitution. But then it is quite problematic because when you ask them which one, is it 1951 when the federal system was, or 1963 when the federal system was abolished? And then they are divided. So, and also, I think we don't have someone like King Idris now with his charisma. So it's a long debate, but I don't think it's a very alternative there. Ideally, and this is what I argued in my paper. I mean, and this was the reason behind the constitution. I mean, at the beginning, I was thinking that having a new constitution would be a good thing. Now, when I reflect on it, it's quite ideal. Maybe it's quite theoretical, but I would think if we think of constitution making as a process, I think it will solve many of Libya's issues. Like if we think about identity, okay, what does it mean to be Libyan, Arab, African, Muslim? I think this is the time to debate that. So I'm just, I mean, as an academic, maybe a dreamer in this case, I would think this is a chance for Libyans to debate these issues and come at a conclusion. This is the time when they decide on the big questions on the new Libya. But the question is how feasible that is, I mean, given what's happening in Libya now. So that's my position. Thanks for listening.
Should I stay here or should I?
As you prefer.
Well, I don't care. It's fine here.
Okay. You don't have a PowerPoint, do you?
No.
Okay. So thank you, Suliman. I think we probably will ask you a few questions about the relation between the political agreement and the working of the CDA, because that's probably also going to be a bit tricky. There's, of course, for those of you who are interested in the region, the Libyan experience calls to mind also a number of experiences in other neighboring transitions, but I think we are now ready to hear a more, global reading of the transition. So, Andrew, you have the floor.
Not just global, because I'm not a lawyer, and so it would be a more general political perspective that I'll argue. Thank you very much, Gianluca, for inviting me, and I very much appreciate hearing Suliman makes a presentation. I've been a reader of his writings recently, and I think he is truly an excellent interpreter and analyst of Libyan developments from primarily legal point of view, though in your essays, political dimension, of course, also appeared. You're absolutely right, Gianluca. This is a second wave of regional clusters involved in democratic transitions, and in each case, too, involved in constitution making. from my point of view, though, the really fundamental difference between the two clusters is that 1989 was post-revolutionary. The only case of an actual revolution break occurred in Romania of that group of countries. Whereas, without exception, since the Tunisian changes in the Arab world, the process assumed a revolutionary character. Interestingly enough, as in the history of revolutions too, we see a heterogeneity of outcomes, greater heterogeneity than in the Central European cases, by the way. You have a relatively successful consolidation, at least so far, of a constitutional democracy on one end. You have consolidation relative of new authoritarian systems in between, and then you have civil wars on the other end. And this is not new, because the history of revolutions indicates exactly this set of problems. From a normative perspective, I myself would always side the post-revolutionary options, not because they're Central European, these occurred in the Middle East, but because not just empirically, but also in terms of their logic, revolutions, as Trotsky and Lenin knew from the outset, involve dual power, at least temporary and perhaps extended episodes of dictatorship, impositions by those who are in position to impose because of their possession of military force, and so on. From a democratic point of view, revolutions have not been generally the ideal or even the most plausible pattern to establish constitutional democracy. Nevertheless, revolutions occur. I don't believe that in most of the countries there was an option for a post-revolutionary negotiated transition forms, Libya being perhaps the most extreme, where there was simply no chance whatsoever to deal with forces of the old regime to produce a form of democratic change. But the chances were not great elsewhere either in the Arab world. We don't have to evaluate those options because revolutions occurred, meaning legal ruptures, at least temporarily dual power, and in some cases also the appearance of civil war. So the contexts were, in general, less hospitable to democratic transitions than the regional set of cases that I examined. Forget now, for the moment, that some of those regional cases, the Central European ones, are now in the process of perhaps de-democratization. Interested, that doesn't belong to this discussion. The modality of transition is not entirely independent, or this de-democratization is not entirely independent of the modality of transition, I would say, but in any case it's based on many other factors too, which we need not discuss. What is astonishing for me, and I've written about this in the context of Egypt and Tunisia, that nevertheless in these revolutionary cases, elements inherited from the post-revolutionary set of options have appeared. I won't discuss this with Egypt and Tunisia now, but I think we can point this out also in the Libyan case. And let me just mention that in common with the post-revolutionary cases of the late 80s and 90s, evidently the Libyan process is multi-stage. There was not a single stage within which a combination of a provisional government and a constituent assembly produced a new constitution with a kind of big bang. An interim constitution is a mark of this, and Libya has the declaration. Sometimes even you look in Google and you find interim constitution in the title, sometimes constitutional declaration. Libya has an interim constitution. Indeed, I think you're still under that interim constitution now, though it has been amended repeatedly as you described. So that dimension too is present. The role of negotiation, I don't know it played much role in the very beginning, but perhaps in a revolutionary scenario that's too much to expect, that those who gain through force political power are going to negotiate, especially not with their previous adversaries. But negotiations appeared later in the case, and one, a fairly comprehensive one, was led by the United Nations in 2015, producing elaboration of not just a roadmap, but also trying to correct the difficulties that have emerged previously, using the institutions, but reorganizing them in a creative way, or at least what looked on paper as a creative way. So negotiations certainly played an important role, and obviously in what you described, various moments of the Constitution drafting assembly, there are important negotiations, and some people exclude themselves. That has occurred elsewhere too. You know, Inkatha Freedom Party in South Africa came in and out of the negotiations, and the white right in South Africa as well. So just the fact that people boycott, then they come back. I mean, this is the difficulty of inclusion in any negotiated setting. Another post-sovereign dimension is the role of the Supreme Court. You mentioned it several times now, and in your papers even more. Most interesting was, because I didn't know about it, because I'm only up to 2016 in my reading, but what is interesting is that even the Constitutional Drafting Assembly, which claimed to have the constituent power, classical European language, sovereignty, full sovereignty, and no control by any constitué, as the French used to say, well, the court said, no, we can also regulate your actions, and this very interesting interpretive matter, whether it's absolute two-thirds or relative two-thirds, is going to be the basis of then counting two-thirds. It could have gone either way, of course, on this. This type of argument has come up in lots of countries, Turkey being one interesting example, was decided by the court. But they decided other matters before. For example, the legality of electing the House of Representatives. You didn't mention that particular feature, and I want to actually turn to that. In your papers, of course, you talk about it. When you said today that Libya has 2 or 3 legislatures, of course, the House of Representatives is one. The second is the GNC. But the mode of election of the House of Representatives was contested and resolved by the court in a way that you didn't find fully satisfactory, and it didn't have the result of dissolving the assembly the way that in Egypt assemblies were indeed dissolved by court order. But nevertheless, the court effected the process at that stage. These are all post-sovereign elements, and for me, they could have been elements, almost all of them, to help stabilize a process, a revolutionary process, which otherwise has fundamental instability. But somehow it didn't work out. Maybe now, in this very last phase, it will, and I of course remain open to it, and I hope you're right that it is going to work. But I still have to raise why, for 5 years, the process has been so unstable. We could just say, in line with my theory, I'm sure many of you don't accept it anyhow, that the revolutionary logic is so powerful that it produces exactly these type of internal conflicts, which are not going to be resolved by introducing a court here and there, or introducing a consensual process here and there. Even the international community, which intervened, but nevertheless did not successfully, or at least not in the final measure successfully, managed to do it. I don't want to just leave matters, though, with this very abstract idea that revolutions produce just a kind of instability. After all, Tunisia, things did, in my mind, at least work out significantly better. So what are the reasons for this particular instability? I think there's some bad choices made. And one probably was, but correct me, because empirically I don't know if the transitional governing council in the very beginning could have itself adopted a more consensual process or not, and established the initial rules of the game in a more consensual manner. That could have been a mistake. But certainly, in my mind, the election of the House of Representatives, which became then a second interim legislature, one of the two legislatures that turned out, I don't understand, really. Of course, politically, I can see how it happened. Politically, it happened because one group within the GNC was dissatisfied with the GNC itself and managed to create a committee, the so-called February committee to which you referred to, which then established the possibility for election of House of Representatives. I'm not siding now substantively with either of these two legislatures. I have no business doing it. But having two means that once very tenuous way you are overcoming the logic of dual power in a revolution, you are reintroducing it. And you're reintroducing it not just in the sense of having two legislatures, but two legislatures having a different relationship to one of the great issues of the day, namely Islam, and two legislatures linked up with two different armed forces. As you say in your papers, it's not identical that each one of them has an army, and the army is to some extent independent of these legislatures, but nevertheless there's a rough relationship, meaning of course that the dual power context becomes especially explosive. Now, would that have happened anyway if they don't elect the House of Representatives? I don't know. But the fact is that once it was elected, especially then it became a fundamental question of where it meets, because where it was, I guess it was supposed to meet in Benghazi, right? But it moved to Tobruk, probably feeling that it would be even more independent of militias there. This then creates not just two legislatures, but two geographic loci of legislation. So this creates, I think, a fundamental problem. Now, in his writings, Suliman also speaks about a fundamental error that has occurred in the process. I want to mention it because lots of people stress this: the absence of genuine participation and public involvement. I have no doubt that you are right about the actual the description that it is relatively speaking absent and not included when it could have been. I'm just not entirely sure that that public involvement could have remedied the problem that is involved, because I think participation also could have been led by political figures in different parts of the country with exactly the same differences, fundamental differences. Why would there be a convergence of public or participatory opinion? And even if there was, in terms of some kind of majority, why would the minority of the public and the minority of the citizen body accept it any more than the minority of parties, minority of regions accept the deal so far? I think ultimately it's the state problem that lies in the back of it. I was even going to give a title to my presentation: Libya, Crisis of Constitution Making or Crisis of the State. It's pretty obvious it's a crisis of the state and of stateness, but which of these two crises is really the more fundamental one? And because you're a lawyer, you tend to focus on the constitutional one. I mean, not that you don't introduce elements of the state crisis at points, but for me, the state crisis, when you say there's two or three of everything, meaning army, meaning legislature, even government, meaning sometimes prime ministers, this means that you have a problem. I mean, to make constitutions, at least in the tradition of work that I work, which is mostly German and French, the idea of making a constitution for a state that doesn't exist, or exists only in terms of fragments that are contending and fighting, seems to be logically not possible. Now, of course, you will answer, the constitution making could actually resolve the stateless problem. But the obverse of that is that the constitution-making process is invaded by the stateless problem, and you illustrated it today. You showed that each and every step, it's like Quebec and the rest of Canada in the vote on the Charlottetown Accord. Agreements would not satisfy either Quebec because it wouldn't go far enough, nor the rest of Canada because they went too far, in that case, in giving Quebec. And this is exactly what you said about the East and the West, as you looked at the different drafts. So I don't know if these matters are irresolvable, but certainly they invade the constitution-making process. And at least where I come from, which is other countries than those of the Central Europe, those of the Middle East, generally we say that federalism is the answer to these stateless problems. I mean, I understand that federalism itself is highly contentious. But in any case, the contention over federalism cannot be resolved by majoritarianism. Now, of course, that's not how you can resolve it, because you have presented a variety of formulas, and I counted them in your writings. Today, you only mentioned, I think, one of them, the regional allocation scheme, which is in one of the drafts, but now it is no longer in the current draft. But extended decentralization is mentioned. Devolution is mentioned, and then I think each time you use the term, it actually means a somewhat different formula. But none of these formulas are in themselves able to resolve the conflict. There are versions like the regional allocation scheme, which is not satisfactory either side, and then the other schemes, which generally speaking are not satisfactory for the East. So there is a problem, and I think you say in your papers that in any case an option that calls itself federalist cannot ever succeed in the plebiscite, in the referendum that will follow. Now, it's a very hard referendum to have anything succeed because it's a two-thirds one. So I'm not sure if any of these schemes you mentioned could succeed any better in a referendum. But my question is, why do you assume that Libya as a whole is the proper unit for a referendum? I mean, after all, you could have referenda also in the three parts. You could have referenda organized according to governorates. And then you say a certain number of them have to accept. But when you say two-thirds of the population, citizen body as a whole, that both creates a very high hurdle, and at the same time, it is prejudiced by its very structure toward a somewhat more centralistic outcome. Now, how does one get out of this kind of trap, right? Because in order to change such a rule, one would require already existing bodies to change them, and most likely one cannot get two-thirds. Who would be now the proper agent to change the rules for the Constitution Drafting Committee, because even that would be contentious. It might wish to change the rules itself, but it would be very hard to achieve the required majority. House of Representatives, now the State Council, because according to the compromise, the National Governing Council has been reconstituted in another form. It's hard to imagine who could actually change this structure. Now, I think, though, I wrote a book on the transformation of Iraq, which is very skeptical about, first of all, the American role, and watching the UN role, not very optimistic about that either in the Iraqi case. A little more reasonable than the American role, but still on the whole was a failure. It's kind of hard for me to reluctantly come to the conclusion that this really requires a very, very powerful, to get beyond these problems, requires a very powerful international role. I just think that Libyans themselves are divided over ultimately who's the demos. Is the demos national or federal? That's what I think the problem is. And you're trying to come up with a constitution without having decided that question. And so I think that it is something that requires referees. Who they will be and how they should be organized would be itself a difficult question. But I think that there are a lot of people, a lot of forces that have a legitimate interest in pursuing that type of role. I mean, right off the bat, Libya's near civil war context is a threat to its neighbors, right? I mean, you can't say that to Egypt or Tunisia it's irrelevant what is going to happen in Libya, right? They also can suffer many of the consequences. I mean, no great fan of General Sisi, but he says, you know, if you have this type of context in which IS can also carve out a part, fortunately it's a very small part, but still, that's a threat to Egypt. And Tunisia, although they have not, as I haven't noticed in your writings, but the Tunisians have involved themselves in any kind of aggressive way, but I think it would be an issue for them. And then given the immigration crisis, it's an issue for also the rest of the Mediterranean, I mean, for Europeans. And of course for the United Nations. I mean, it is a purpose of the United Nations to actually maintain international and regional peace. And this kind of context is a threat to it. So I think that that something like a much broader form of international participation, relying on a conference of a more extensive and more active sort. I'm not quite sure who negotiated the accord, but it looks to me like it was just basically a United Nations role, and that means that there are other actors, other countries in the region who, this has been true for some European countries, even the United States, and certainly for Egypt as well. They can make the deal not work. So I think that there is a need for another. I mean, maybe that you're right, that this particular constitution will in fact be voted in, and maybe it can even be approved in a referendum of 2/3. I'd be skeptical, but on the other hand, it's possible. But it's not just the 2/3; it's the ones on the east who have to accept it, who will lose in the referendum. And their military forces at their disposal, which they're not going to give up. So even if you actually did it, could this thing work? And I'm skeptical that without some kind of historic compromise over the question of the state, that the Constitution in itself can succeed. Now, what would the compromise look like? I think, in a way, federalism has more forms than you seem to discuss in your paper. You seem to discuss decentralized forms of various kinds, but those decentralized forms always have the priority of national government over localities and regions, and I think one needs to have more autonomy in a future Libyan federalism. I don't know if the one in 1951 wasn't a constitutional state, but there was a constitution involved, for example, having constitutions for each of the regions. I think it's very important in the federal setting that the parts also have constitutions. And that can also happen in a more centralized version of federalism like India's or Germany's. It doesn't have to be the US form. It's also in the Libyan context extremely important, and you seem to say that the last agreement moved away from that. It's extremely important that federalism doesn't produce a setting in which one part of the country is impoverished at the expense, one part of the country is impoverished while other parts of the country are enriched. Whereas previously you might have thought that I'm taking an Eastern point of view, which I'm not, but I am only because I also think federalism is right, and they mostly the people in the East who think so. On this, I would be Westerner because I think it's extremely important that that the West and the South are not then impoverished by some kind of federal option which gives each of the three regions full control over their own productive sources. So both an agreement which is more federal than anything that seems to have been discussed so far, and at the same time more equitable in terms of economic justice would be the one that would be what I would be looking for. And I'm just skeptical whether the current draft is going to achieve that. And I'm also skeptical that even if it is then voted in, that it will be accepted by at least a significant part of the country, which has the means of resisting any kind of imposition. Okay, thank you very much.
Thank you, Andrew. Before I open the floor, just very quickly, if we were to put it on a higher theoretical level, do you think that there's any responsibility in the fact that mainly the major international actors, but also the local actors, have heavily rested their positions on the scholarship that came out of the Central European transitions? And since, as you correctly pointed out, the situations, the contexts are very different, just relying on the scholarship that was developed and the kind of formats of transitions that were analyzed after 1989, and just plugging them in the Egyptian context, in the Libyan context. I mean, what was the responsibility of that? Of that scholarship not being critically adapted to the different contexts? But I'll leave it there and see if there's any question in the audience.
Okay. I have a general comment. Okay. My name is Ali Sadra. I'm a lawyer, and obviously, it's very clearly we had the issue of identity as to the question which the identity that will be reflected in a social contract among the Libyans. That social contract should reflect, as rightly the lecturer has said, the minorities, the East, the West, and the South, and reflect different ideologies. My question is that the social contract is usually comes as a result of the evolving of the independent will of the Libyan people themselves. And if you remember, at the beginning of the revolution, Gaddafi himself asked, he said, "Who are you?" And the Libyans replied very clearly, and they said, "We are Libyans, we belong to the East, to the West, to the South, and we are Arabs and we are Muslims." And they said, "We are Tabu, Tawarek," all this. So they, in the mind of the people, there was a general picture which can bring them all together. But when it comes to the wealth and it comes to the power that protect that wealth, mainly the national resources, then there, a conflict has arisen. The international society did not help Libyans in a sense that they have given the Libyan the right environment to help them to dialogue and negotiate, to develop their independent will, to draw their social contract. So it allowed the interference regionally and from other areas. And in my opinion, the National Congress at the beginning, when they have drafted the interim constitution, they were quite, they have really helped in that, but they had one issue. They did not made a lot of effort in educating the Libyan population. They did not create public awareness. They were much involved in different areas other than creating general awareness and knowledge of what is the constitution. Remember that Libya 42 years left without a constitution. So imagine the people, what is their understanding has really been reflected by that big gap of no involvement of rule of law. So my question is, what is the political agreement that has been signed in Sakhairat? Do you think will that help the process of reaching a consensus, or do you think this is, what is your opinion about it, please?
So it actually links to what I said earlier, I think. So it pushes you to somehow answer it, right? Because of course, what the question was referring to is the political agreement that was signed in Morocco and Herat, right? That was then changed in Hammamet, which is what allowed the recent draft to actually be released. So this relationship between the political agreement, or what you called at the beginning the social contract, and then the functioning of the CDA. So in that sense, if I can, I might also rephrase that in partially to Andrew. What is the role of size of the drafting or the Constitutional Assembly? Because if the drafting committee is a 60-member committee, is that just for drafting, or do you actually need a wider body to actually properly have, the possibility of crafting a social agreement or a social contract or a political agreement, right? If I think if the Italian experience was a fairly divided society after the war, but the Constituent Assembly was a wide enough body so that the parties in there could actually battle out, which way are we going? Are we going east and west or west? And what are the main decisions? But it was like I think a 500 or 600 member body. So do size matters in these contexts? Yeah, go for it, and then I'll give the floor to them.
First of all, I'd like to thank both lecturers. My name is Abdul Rashid Beiga, Director of Arato International Human Rights Monitor. My comments and questions are directed to Mr. Suliman here. He started with a point which it's a finish and a start as well, Libya today. And can we form a constitution in a conflict? And what effects does it have on the design of the constitution, the factors around it? And there's another thing which we kind of slipped away from, and that is the constitution before 2011. So we're talking about 42 years ago, and we said that the monarchy was a constitution as well, separate from the 42 years before 2011. So when we say that we need a new constitution now, what was wrong with the constitution before? What are the factors that need to be changed? What is the new identity of a Libyan citizen now? Why does it need to be changed? Is it the factors, or is it more political factors, as Andrew here said? Is it more political factors rather than identity, society, citizenship, and the law aspect of it? Is it more Sharia law? Is it more human rights? Is it more? What is wrong with the previous constitutions? And I think if we got a conclusion from that, it will help to further understand what we want from this new constitution. The question is, now leave my comment aside, who protects the constitution? And what process was the drafting assembly chosen by? What was the process in which the assembly was the drafting assembly chosen by? How were they chosen? How were they appointed? Do they represent certain, as you segmented it first, you said it was 3 parts of Libya, and then you further segmented the map to minorities and different minorities, different groups or Libyan groups. Thank you.
I think we have time for one more question, if there is, and then I'll give yes, please, in the back. Do you want the floor as well? Yeah, sure.
Hi, thank you so much for this really interesting to hear analysis. I've been following the drafting process since 2014, and I would absolutely agree with the comments on what the roadblocks are, what the main sticking points in terms of the discussion. So obviously, federalism, the relationship between religion and the state, and then other details like part of the identity and the flag and the anthem and so on. I just wondered what your thoughts are on whether, in the constant sort of back and forth on those key points, other elements of the Constitution have maybe been a little bit more neglected. Because when I look at the most recent draft and previous drafts as well, I don't think that the human rights are as strong as people would have aspired them to be. I think the judicial section is odd and other elements too, so it could be improved, and I wonder just, if you agreed or if you had thoughts as to why that might be.
You wanted the floor, right?
Thank you very much for the chance to ask the question. I'm interested in the legal implications of the fact that the Constitution hasn't been approved or ratified by people. What's the implications for the Siraj government and its ministries when they sign contracts or act on the international stage? Could they at any time be told that their actions and their signatures on contracts and other agreements are invalid because they haven't actually been constitutionally set up under a constitution?
So one last question here in the front, and then I'll give the floor to the speakers.
Okay, thank you. Thanks for the talk. I have just a few comments. The first about the Constitution. I think the mistake we made from the beginning, that we elect the Constitution Committee. And I think it was better if we nominated the Constitution Committee, because election, it puts the difference between peoples, okay? The difference, because everyone elected, he comes with his idea, or the idea of the people whom they elected him. And this was really a big mistake, and myself and many people I know, they were against this from the beginning. The second point I'd like to talk about it is the minority. When we are talking about the minority, I'm myself from the Berber, okay. When we talk about the concept of minority, we are dealing it in the wrong way. Because in Libya, or at least the Amazigh, they believe that they are a linguistic minority. It's not a racial minority. They believe that the Libyans is Berber by nature, okay, and they became Arabic in nature later. So that's why they would not agree about the constitution that eliminate the Berber race. They like the title for the Libya to become a Libyan state, or Libyan Republic, not Libyan Arabic. So they are not looking for Arab, they're not looking for Amazigh. The majority, I'm talking about the majority. And here, because there is a difference between the rights, there's what we call it a natural right, and there's what we call it a political right. So for example, federation, people asking for federation, they are talking about the political right, and the political right can be debated or can be put under referendum. So people, if they choose for the state to become a federal state, so they have this right after the referendum. But you cannot referendum a right to the natural right. And I think this is one of the points that the Constitution didn't take it or didn't talk about it. Thank you.
All right, so
yeah,
I
can be relatively quick, because obviously I'm not the one to answer questions about Libya, really. But some of the points made were really interesting, and they do touch on my interest. It's a very interesting remark you made about nominating and electing. I mean, the round tables, which I work with, have had nominated members. The way it typically would work is that the governing party would choose one opponent, and then that opponent would say, yes, but I want them, and then somebody else would complain, and they would include, but none of the members would ever would be elected. And in the situation that we're speaking about, what you have initially is the constitutional declaration made by the basically a provisional government, the transitional governing council, which is neither nominated nor elected, but a body that has been able to take power, basically not in the whole country, but in sufficient part to be able to declare what the Constitution is for the time being. And then comes the election, which then, as you say, does not provide a sufficient foundation for inclusion, given the complexity. This is a very complex society, minorities, different attitudes to religion, regional issues. To really have full representation. Representation need not be electoral. To have a really full representation, it would have required work. And somehow that didn't occur, and they are trying to constantly, in the middle of the process, readjust it to make sure that it is working. But in fact, it tends to produce defections more often than even new forms of inclusion. So that's I think, a question which then relates to the 2 points that Gianluca made, because size then does matter. If you're going to have a problem of inclusion of so many different ways of being political in a society, you need a larger size. I don't like very large sizes for these kinds of things because they really become unwieldy, and in fact, in the end, it's internal elites and internal experts who dominate a lot of the process. But maybe 60 in this case was just too small. That's for you to say, because I can't really think out how many important groups would feel neglected and could have been included on a larger basis. But certainly there's no point in making it that small, and so they could have made it larger. And that brings me to your other question, Gianluca, about taking the experience of these 1980s things seriously and applying them here. I mean, that criticism is most relevant to my work, because I'm not so sure that there are so many people who do use formally in their analysis 1980s and 90s as their guide for analyzing these processes. But it is not just theorists, and this is the more important part, but it is also activists who are influenced by international discussions who then bring in criteria that come from other places. That's why we see such extended negotiation in Tunisia. That's why we see the role of courts, which would have been excluded a generation before, and now they're everywhere, right? Not Tunisia, actually, interestingly enough. They create a strong court, but the court did not play a role. It wasn't strong to begin with in the transition, but the Egyptian one is a major participant, and so obviously the Libyan. I'm willing to say, we should not take models from post-revolution to revolution because they are so different. But then the question is, what's the alternative? And I think firmly still that a purely revolutionary option of constitution making would have been a much greater disaster in this case than even what you currently have. Because what if the transitional transitional governing council would have thought that they themselves can remain in power, this is a typical revolutionary scenario, until a constituent assembly is elected under their supervision, and they will continue to interact with it. You've seen what form that interaction sometimes takes in the case of Lenin, who gets rid of the constituent assembly. But almost everywhere, there's an interaction where the constituent assembly is to some extent controlled by the provisional government. I think in this setting of complexity, that would have been worse. And there's no reformist option, because you can't expect the Gaddafi regime to reform itself and make a constitutional democracy. So I'm not so sure, unless something entirely new needed to be developed, I'm not so sure that the form that I would rely on is not at least a pretty good starting point. I accept your point for Egypt, for example, that there the role of the court, which is so positive in South Africa, has turned out to be disruptive. So I can see that that taking form from different types of political and transformational context can be dangerous. But at the same time, it seems to me that that's not obvious in the Libyan case, that the court's role globally was negative, or that the fact that there were negotiations in the middle of the process was bad, or that the process has many stages in which one tries to make a constitution and actually has already made one and drafted several others. So I see your point, but I'm not sure if in this particular case we have a very good alternative.
Suliman.
The quick one, the points you mentioned, and also the question about the political agreement. I see the political agreement as a problematic one. I mean, as a lawyer, even in terms of the phrasing, the writing of the political agreement itself. And once we had the chance to speak with someone, one of the UNSMIL, the United Nations mission, who was involved in the process, and he said we had no option because simply we were like simply moving between the two sides and having to amend the provisions. So why it appeared in this problematic way? So when it comes to the CDA, the Constitutional Drafting Assembly, it is mentioned in different provisions. And actually there is a whole section, 5 articles about the CDA, but nothing real is there. I mean, the big issue of the 2/3 needed for the referendum is not mentioned. It's simply good wishes. So they should, all the parties, the GNC, after later becoming the State Council, the House of Representatives, should make it easy for the CDA to work, should respect its independence. I think the only real addition was, okay, if the CDA wouldn't be able to finish the draft before the 24th of March 2016. So this was the real addition because it gave the CDA more time, because the deadline was October 2015, and now the political agreement gave it 6 months. Then in this case, both parties would have to meet and then discuss the alternatives. So this could have been a chance because actually the CDA failed to meet this line. Had the political agreement been successful, we would have had those parties coming together and discussing alternatives, could be retaining the old constitution, being content simply with the constitutional declaration, but this didn't happen because the political agreement simply failed. And this leads me to the other question about, okay, what effect if the constitution making is not successful, what effect this will have on the current government, the Sarraj government, for example. I think because Sarraj government is not based on the upcoming constitution. I mean, simply all these, I think Kobler mentioned this in his meeting last week or something, is that all the institutions now, I mean, there is a question about the legitimacy of all of them. Because legally speaking, they should get their legitimacy from the political agreement. Because every one of them, the House of Representatives, the GNC before, the State Council, simply they all passed their term. It is the political agreement that will give, yeah. But the political agreement now hasn't been incorporated in the constitutional declaration yet. So it is problematic. So even the House of Representatives extending its own mandate is not legal. So let alone Sarraj government, which hasn't...
Who could amend the declaration now? Who has the power, the right to amend it?
That's the question, because in the political agreement should be incorporated in the constitutional declaration.
Yes.
And the provision was drafted in a vague way, so the GNC, the former GNC, claimed it has the right. So simply the GNC amended the constitutional declaration for the 9th time. And they said, okay, according to the political agreement, we are the one. And then the House of Representatives now is objecting to say, okay, we will not amend the constitutional declaration until these conditions are met. It has already been incorporated by the other body. So it's who will amend it? That's the question. I mean, so it is, and that's why, I mean, since the political agreement hasn't worked yet, so everything concerning the CDA simply is pointless. I mean, even the deadline has long passed. So I mean, the constitution, you mentioned, what about the constitutions before 2011? I think the two possibilities is, if we are talking about Gaddafi's time or the monarchist time. The monarchist time, there was a constitution, 1951 until 1969, and some people argue still valid because Gaddafi's regime simply didn't abolish it. Simply the Constitution Declaration of 1969 abolished the chapter concerning the monarchy, but not the whole. So that's a question. But it is problematic because it was drafted in 1950. So in terms of human rights, in terms of it wasn't a constitutional monarchy. Simply the king had lots of powers, I mean real powers, not just simply symbolic ones. So, and that's why some people say, okay, it's we should be more ambitious in 2011, having this revolution and simply getting back to 1951. During Gaddafi's time, there was no constitution. I mean, the ideology itself was against having a constitution. The real constitution would be something from the sky, from God, or something from custom, from people. Yeah. There was a debate. Okay, at the end, the debate ended by, okay, in Libya there is no constitution, however, there are laws that have this constitutional nature, like the Ta'ziz al-Hurriya, for example, the Green Charter, for example. Okay, but no constitution per se. And even if there was one, I mean, it was no question in 2011 to simply bring back Gaddafi's constitution. It was seen as simply against the revolution. So how the CDA was chosen? Simply it was elected. I think no one disputed the integrity of the elections. It was like a very low turnout, but I mean the integrity of the elections, the transparency, I think, personally I haven't come across anyone questioning it. I mean, but it was a very low turnout. The neglected points, I mean, I agree. I mean, it was a question. We have had many encounters with the CDA members. And one big question is how detailed you should be. Some of them, and I think this was the preference at the beginning, you should go as detailed as possible because this is the time to protect whatever you think important. So in terms of human rights and freedoms, I think chapters were very detailed. In terms of the judiciary, for example, we have this concept from Gaddafi's time, Mohammed Shabiya, the people's lawyers. That's something that was created there, and it has been a debate since 2011 whether to keep it or not. Personally, I'm in favor of keeping it. It has many advantages regardless of being created by the old regime or not. However, in the previous drafts, it was simply targeted for this ideological reason. Now, the preference seems to be for like, okay, what's the proverb? The devil is in the details or something like this. Yeah. So they said, okay, maybe now we should omit as much as possible. So when it comes, for example, to the nationality, whether Libyan women could pass their national, okay, that was simply, okay, left to an ordinary law, non-constitutional law, to avoid any trouble. So I think that was the reason for neglecting, not mentioning these important points. I mean, whether appointment was better, I think at the time maybe we had a debate. I remember this huge debate there, but it was no option. Even the NTC, the Transitional Council, when it was at the end, and it was quite controversial because it was almost the end of its term, amended the Constitutional Declaration, opting for election instead of appointment. So I remember there was an appeal before the Supreme Court, and the Supreme Court said, okay, the Transitional Council had no right to do so. So now it is back to the General Congress simply to retain the status quo, which is appointment. But the GNC also was forced to keep that amendment because appointment was no option. I mean, the atmosphere at the time didn't allow for keeping the appointment. Simply, election was the only option at the time. Whether these 60 members, I mean, 60 is too small, I think we are already having troubles with 60 members, with 60 members. I mean, I remember spending 2 days in Beirut with them, I mean, as part of the university delegation. We found it difficult. I mean, like, some of them actually were we felt it was personal sometimes. I mean, everyone felt like, okay, I'm defending Cyrenaica, I'm defending Zwoya, my own tribe in the south, I'm defending Tabo, it was like something, it wasn't even the willingness to have that debate. So I mean, like having more than 56, I think will be very problematic, I would think. The NTC the NTC have stayed. I think I remember in 2012, this was, I don't know if it is the revolutionary euphoria or anything, but people simply came to their senses in a way. They said, no, this body is not elected. Enough. I mean, like it's overseen the transitional period. So, like for 2 years now, we should have another body. So simply, the MTC was forced to step down and to amend the to have the constitutional declaration and the roadmap, a new elected body. And the same with the GNC. The assumption was the GNC would simply oversee the whole transitional period. But in 2013, it became impossible. At the end, it was simply forced to step down. It tried in different ways, scenario A, scenario B, amended the constitution for the sixth time. But at the end, it had to give them.
It both helped to elect a new body, and then it stayed on the top of it too. It didn't actually step down, because you say, well, it could not have continued, but it did continue. It gave Libya 2 legislatures instead of 1, right? So, I mean, if they were going to stay, then it was not a great idea to have another one.
Yeah, it is quite complicated, because the assumption was, okay, once the House of Representatives would be elected, then the GNC, the General Congress, would hand over the power. But I mean, for reasons, for example, maybe my fellow Libyans here could correct me, but the picture at the time, I mean, of the GNC was, okay, this is a body dominated by Islamists,
yes,
and simply they spoiled the politics, and now it is time to get rid of them.
They lost.
And
yeah,
then,
the election turned out badly.
Yeah, and then when the House of Representatives was elected, the results were clear. Islamists didn't win there. So, and that's one explanation of it. That's why they use this, okay, you should have convened in Benghazi instead of Tobruk. But that's, I think, just a procedural thing. This is just the means. But I think the real reason was different, because, and also the other party, to be honest, I mean, to be objective, the other party wasn't also acting in good faith. I mean, Tariq Mitri, who was the predecessor of Cobra even before, when he tried to negotiate, to open this dialogue between them, the civil current, he said simply, we are not negotiating with the losers. I mean, he said that in his book. So you'd see, I mean, it was problematic from, I think, more than one side. Role of courts, I mean, this is the last point. I think it's interesting to observe in Libya now. I mean, everyone now, not everyone, I mean, it's often the case that rely on courts. The Supreme Court, in this case, abolished the 7th Amendment, resulting in the House of Representatives being unconstitutional. Whether it was wise, that's the question. Maybe legally speaking, I mean, if just you pick up the details, okay, technically speaking, it was the right decision. But was it the right decision to leave the country? It's like rewarding the perpetrator in a sense, because the GNC simply now, because of their mistake in taking the decision and not observing the procedures, they came back. So it's like, okay, they're rewarding them for their, and the same now with the exchange of fire by courts in Tripoli, the courts in Beida, annulling this decision. So the question is, should courts be involved in this? Is there a way out? The Supreme Court sometimes do it, simply keeping something in the drawer without deciding on it. I mean, the interesting example of the constitutionality challenge. I mean, women shouldn't be judges. Challenging the constitutionality of a law that was introduced during Gaddafi's time, saying, okay, this law simply by allowing women to be in the judiciary simply is against Sharia. This was, I think, in 2012, 13, something like this. So, Supreme Court couldn't decide. So simply, up to this moment, we haven't heard about this case at all. I mean, like, just simply, it's on the shelf there, so ignoring, not making any decision. Because either way, they will be doomed, whatever decision they take on the issue.
I hope you appreciate the fact that the room temperature was brought directly from Fezzan to make the experience more real. Let me just remind you that on your seats you have the program of the other dialogue series that we will have in the fall. We have the first in October on governance and public health in early 19th century Egypt. And then a second one in which we're going to bring back the region and Central Europe with governance and academic freedom in Turkey and Hungary. Please take the postcard with you, and let me just ask you to join me in thanking the two speakers for the fantastic conversation that we had tonight, and for all of you, happy summer and Ramadan Mubarak to those who celebrate. Thank you.